versus Michelini. Okay. Mr. Barak, you're up, sir. Are you going to reserve 5 minutes?
Yes, please, Judge Morris.
Okay, all righty. Please proceed.
Thank you. May it please the court, Ryan Barrick, Qual Barrick Nadu, on behalf of petitioner defendant Jonathan Godwin. This is a SLAPP lawsuit, a defamation lawsuit brought by a well-known Tampa lobbyist, Stephen Michelini, associated with 2 Facebook posts that Mr. Godwin made under a pseudonym. They were posted on the discussion forum of a Facebook page for the Tampa Bay Times about a January 20th, 2022 article entitled "Text Messages Raise Questions About Tampa City Council Members' Impartiality."
Mr. Barrett, can I interrupt you, because we've read read this file thoroughly, the briefs. We know the facts. It's a very interesting case and a very interesting issue. But it seems like our case of Davis versus Mishiev controls it. It seems like it's right dead on it. Why does this case not control the outcome?
I think Davis does. The trial court did not use Davis, Your Honor. So we think we are squarely within Davis and Gundel. And
counsel, your opposing counsel makes an argument that in fact the court did apply the burden shifting test, but I couldn't really understand where that came from. Do you understand that argument?
I don't, Your Honor. I mean, the transcript doesn't reflect that. The court didn't suggest at the hearing that that's what it was she was doing. The written order does not suggest that either. The court at the hearing,
it seemed to me that the court at the hearing applied the traditional motion to dismiss test of whether or not things are accepting as true everything that's facially alleged, rather than the burden shifting that we've discussed in Gundel and in Davis and in Baird and a whole line of cases.
I would agree, Your Honor. I think while I have respect for the trial court, I think she erred in this instance by not applying that burden shifting framework. Our briefing asked her to do that, but she did not at the hearing. And I think there was
in your view, is this case as simple as that it needs to be sent back down for the court to apply the proper test for a motion to dismiss on a SLAPP suit?
I think so. I'm going to give you the lawyer answer. Yes, but I think yes, it should be remanded to allow that. But I also think when this court, if you look at the facts of this case, the instructions to the trial court should be very clear as to what the outcome should be, because this is the slappiest of slappy lawsuits. I mean, it is an extraordinarily strategic lawsuit against public participation, more so than even Gundel or Davis. I mean, this is a case about core free speech, core commenting on the operations of government. Davis was a case about a rapper and a radio guy, and Gundel was about a homeowners.
But your complaint in this case has to do with the allegations of corruption, correct?
That's right. So but
the article itself that spawned the Facebook comments really isn't about Godwin's corruption.
In fact, the article, and this is an error that the defendant, the plaintiff, Mr. Michelini, repeatedly makes. He says in his opposition to the trial court and in the respondent's brief to this court at page 29, he claims that this January 22nd, 2022 article, which is Exhibit A to the complaint, hardly mentions Michelini at all, and chiefly discusses Mr. Dingfelder's resignation from city council. That's just not accurate. The article mentions Mr. Michelini 14 times. Councilmember Dingfelder didn't resign for another 2 months. This article is all about Mr. Michelini. It talks about Mr. Michelini and his business before council. It talks about whether or not Mr. Dingfelder should continue to vote on matters where Mr. Michelini is lobbying council. It has other members of council accusing Mr. Michelini of lying. And it has assertions by Mr. Michelini's lawyers that Mr. Dingfelder should not continue to serve on council at all. It even contains quotes from Mr. Dingfelder saying that he was sued by Mr. Michelini because they were trying to silence him for defending the rights of neighborhoods. I mean, this case, the article that is at issue, which is again attached to the complaint, is entirely about Mr. Michelini. Like I said, it mentions him by name 14 times. It mentions his lawyer, Mr. Loeb, repeatedly. I mean, it's all about Mr. Michelini and allegations of him lying and his conduct. And so the Facebook comments, which were offered in response to that article and by a prompt from the reporter, are all about those same things. And to be clear, they only got a few likes. I mean, I think they got like 3 likes. So yes, we believe that this case is controlled by Davis and controlled by Gundel, and that the trial court should have engaged in that burden shifting analysis. And if they had engaged in that burden shifting analysis, the case would have been dismissed, because this is, even on just looking at the way the complaint is framed, it is absolutely a slap lawsuit. And the comments are absolutely about this article and Mr. Michelini and his conduct at council and council members' conduct. Let's be clear, this is about council members' conduct, and it is related inherently to the allegations put forward. I can also address the court. We also filed evidence that we believe the trial court should have considered in ruling on this if it was converted to a motion for summary judgment, as is contemplated. The trial court found that we did not provide any evidence. That is just not accurate. We provided substantial evidence. There seems to be a disconnect between the analysis.
Well, the trial court ruled against on the motion for summary judgment because there was no affidavit evidence.
Correct.
The argument is that under the SLAPP statute, you don't need that.
That's right.
That was the argument.
Yes, and you don't need, under the new summary judgment standards, you don't need an affidavit. The question is it reducible to an admissible, would it be reducible to an admissible form at trial? And in this case, the evidence that was submitted, if it were dealt with as a summary judgment motion, would have been admissible for summary judgment purposes at trial. We're talking about government records, the City of Tampa Code, and government records that are publicly available, public records that reflect that Mr. Michelini was not registered as a lobbyist for much of this time. These are records of newspaper articles reflecting Mr. Michelini's various lobbying activities, which are self-authenticated. So if there were, and the plaintiff never disputed the facts that were asserted. They just said, well, there's not evidence. There was in fact evidence, and the trial court just said, well, there's no evidence. That was not accurate. That is not what the record reflects. That is not what was put in the record. That was not the arguments that were presented.
Of course, all those decisions on the merits would, if, as far as we would go at this juncture, would be to possibly reverse, and for lack of applying the burden shifting analysis that the cases require, and then the court would have to get into the merits of whether or not it passes muster or not.
I respectfully, I understand that this court's review on a petition for writ is generally to instruct the trial court with respect to applying the proper test, and allowing the trial court in that first instance to apply the proper test.
But you're asking us to opine on the lack of evidence or the evidence or lack thereof.
I mean, I would say that, again, I'm very mindful of the court's role and I'm very respectful of it, but I'm also mindful of sort of the efficiencies of life. And this is an instance where it may be helpful for the court to perhaps go a little further than it might in other instances, so that it's clear to the trial court, perhaps how, and maybe not, but I think that this is a case where clearly we have the core First Amendment issues in play. And it really, this is a case that screams out for the application of that burden shifting analysis, for the application of the standards that this court has set down, and for the application of the protections that we enjoy to engage in the public discourse. Seeing no additional, if there are any additional questions, I'm happy to answer them. If not, I guess I'll reserve my time.
Thank you. I think you hit the high points. Thank you. Mr. Geisler, it's your time, and I've got 3 questions. Should I just go ahead and start asking them?
You're the boss. Go ahead.
Well, I mean,
By all
I
means, for the
believe in
record.
trying to get to the point, not taking your time unnecessarily. So,
Absolutely.
first of all, is this a lawsuit, a strategic lawsuit against public participation?
Absolutely not.
It's
And
not.
in
Okay.
answering that question, I would respectfully disagree with Your Honor's hypothetical or suggestion that this case is controlled by Davis versus Mishiev. In reality, I believe that the case, the opinion of this court that compels the result here is actually the Baird decision. If you look at Baird, the facts are actually fairly uncannily similar here. You have a situation where statements were prompted by a news report. In that case, there was a parent who was upset with the conduct of a school, of a charter school. He wrote on social media, he wrote a 24-page missive explaining some of the reasons why he was upset, and alleged all kinds of any manner of things, including illegalities. This caught the attention of the newspapers. The newspaper ran a story on this, including a comment by the attorney for the school. And in response to that news story, the plaintiff in that case, or the defendant rather, filed another social media post, 21 pages this time, rebutting or attempting to rebut the statements made by the school system. The court there, the trial court in that case, made its finding that this was not an anti-SLAPP suit, that the statements were not protected by the First Amendment because they were false and because they were not made before a governmental entity. The court in that case, and it was eventually affirmed by this court, said that while in some instances, if these comments had been made before a governmental entity, for instance, in front of the school board or in front of some sort of governmental review board or the prosecutor, they would be protected. The fact that they were made on social media, even in response to a news story, meant that they were not protected by the First Amendment, and therefore that SLAPP statute did not apply. Something that needs to be.
Mr. Geisler, the facts in Baird also, there were additional allegations that I don't think we have here that included interference with contractual contracts. So doesn't that make a difference?
It doesn't, and respectfully, Your Honor, it doesn't make a difference. The case law views those tortious interference cases essentially as retooled, and this is typically in the context of government privilege, but they consider them subsets of or retooled defamation claims. And the case law interpreting those and applying the anti-SLAPP statute are the same. If anything, the facts because some of the statements in Baird were made before a governmental entity, if anything, the facts are more forgiving of the conduct in Baird than they are here, where the allegations are exclusively on social media. There's no allegation in any sort of public inquiry or anything of the sort. These are purely personal statements. And I think that to some extent, even the briefs, respectfully, I'll fall on my sword a bit for that, bury the lead. And the anti-SLAPP statute requires a showing not just that First Amendment activity is being engaged in, but also that the lawsuit is without merit. And in fact, the without merit part comes first. And neither, while Mr. Barrick's brief discussed the merits of the lawsuit, without merit is an entirely different standard. And I think that when you look, it is true that the order in this case, which generally, or very specifically actually, tracks the language, the oral pronouncement of the court. What's important to remember in terms of this burden shifting, or in terms of the fact that the court applied a standard or traditional motion to dismiss analysis, is that Mr. Barrett filed a traditional motion to dismiss as well. If you look at page 39 of Mr. Barrett's appendix, there is a motion filed under the anti-SLAPP statute under 768.295. There is also a motion to dismiss filed under Rule 1.140 and a traditional summary judgment motion filed under 1.510. These things address two completely different standards. The purpose of the anti-SLAPP statute is to determine whether on a motion to dismiss or on motion for summary judgment, whether or not the anti-SLAPP statute applies. It is not a license to skip to the merits of the case, to skip to the ultimate resolution of the case. That without merit does not mean the substantive merits of the case. It would be akin to a gatekeeping operation where you're dealing with something similar to 57105 in terms of a frivolous or a completely meritless lawsuit. So when Mr. Barrett references the affidavit standards of 1.510, or when the trial court referenced the traditional failure to state a claim standard that applies to a regular motion to dismiss, that's required because the motion was filed in which he's entitled to do under all three of those standards. So the court was
Mr. Gessler, where did the court do the burden shifting analysis required under the statute?
The order does not reflect this, nor does the court's language. This is in an ideal world, the court would have said the prima facie case was not made. The order does not reflect this.
You're speculating that the court actually did undertake the burden shifting, although there's nothing in the record to indicate that the court did undertake the burden shifting.
I am, Your Honor, and the reason for that
in Barrett, it's very clear that the court did undertake the burden shifting and ultimately concluded that there was no departure from the law.
It's unclear, and the reason for that is in this court's decision in Baird, this court assumes or presumes for the sake of argument that the prima facie case was made. If you look at Baird, it says we're not even going to get in. This court says we're not even going to get into the question of whether or not the prima facie case is made, because even if it were, MCA, the charter school in that case, satisfied its burden to rebut the two prongs of the anti-SLAPP test, which is A, that the case was without merit, and to be clear, the standard is conjunctive. Both prongs of this have to be made, and B, that the conduct at issue was protected by the First Amendment or was motivated primarily because of public participation. So the court in Baird said it doesn't matter whether or not the prima facie case was made by the defendant in that case, because the rebuttal under Gundel and Davis was the rebuttal prongs were satisfied. And that's what I would argue as a saving construction here. That's what I would argue the court determined. I believe that the court, if you look at the argument in the case, the transcript of the hearing, and if you look at the briefing, or for lack of a better term, the motion to dismiss and the response in opposition, this is not an instance where there was a dispute about the standard of review and the court picked the wrong test. The court, there was absolute agreement about the burden shifting. Our response in opposition to the motion to dismiss makes clear that our argument was not that there was no burden attendant to Mr. Godwin, but rather that prima facie case was not made because, respectfully, contrary to Mr. Barrick's certainty about the anti-SLAPP nature of this of his client's conduct, I would argue under Baird, there is far more uncertainty about whether or not this was actually protected conduct of the First Amendment. And at the very least, there's extreme factual disputes about the truth of his statement or his statements. I would remind the court that while there was no affidavit filed on behalf of Mr. Godwin, Mr. Michelini did file an affidavit absolutely disputing on the merits the allegations made in Mr. Godwin's anonymous statements or pseudonymous statements online. And in that respect, I would contest what Mr. Barrick said, that the truth was undisputed.
One final point about whether the judge actually engaged in the burden shifting. At page 28 of the hearing transcript, the judge says almost apologetically, "For such experienced counsel, I don't mean to be basic, but that's what we have to go by." To me, that says we're going to use the traditional standard way of assessing the motion to dismiss. And I'm sorry to bore you because I know you've all been through it many times before. And then the court proceeds to handle it in that way without mentioning the burden shifting mechanism.
That my reading of that is that the court had decided that there was no prima facie case made and turned the trial court's attention to the 1.140 motion to dismiss, which again was explicitly on Mr. Barrick's terms. So it would have perhaps been better for me right now to argue had there not been a conflation, or had the lack of the prima facie case been made explicit. But my response to that is twofold. One, that it is implicit, that the court decided that there was no prima facie case made and that the anti-SLAPP statute did not apply, therefore turning her attention to the merits of the case and the failure to state a claim allegation that found in the motion to dismiss. And two, that even if she did not decide the prima facie case, that, and I'm hesitant to invoke the tipsy coachman doctrine here because I know the court's thoughts on it in general, but that something akin to that or analogous to it is in play because of the extent to which the rebuttal standard was met by Mr. Michelini in this case, owing to the affidavit and the exhaustive analysis of the reason why not only is this case not without merit, but actually on the merits, a prototypical case of defamation that therefore is carved out of the ambit of anti-SLAPP.
Mr. Geisler, you've answered my second question already without me asking it. You've just spent a lot of time talking about it, but I still have my third question. So I want to go
Yes,
ahead
sir.
and give you a chance to respond to it. We're here on a writ of certiorari, of course, and in order for us to invoke our certiorari jurisdiction, we have to find that there was a departure from the essential requirements of the law by the trial court, resulting in irreparable harm. Is the harm here irreparable?
So with regard to the extent that the order in this case is a denial of a 1.140 motion to dismiss or a 1.510 motion for summary judgment, the case law is very clear that there is no irreparable harm, that the remedy in those instances is a post-judgment appeal. With respect to the anti-SLAPP, with respect to the order as it applies to the anti-SLAPP statute, the invocation of the anti-SLAPP statute, under this court's precedent, certiorari, I concede, is the appropriate vehicle. Now, as this court is aware, there is a difference of opinion.
I ask you the hard question. Are we right?
So
you know, not everybody agrees with that.
I do, as a matter of fact. And if the court, as the court is likely aware, there's a case out of the 4th DCA that's currently on review and conflict. And if you check the names on that, on the plaintiff in that suit, you'll see one that looks familiar from today. So I'm so intimately familiar with the disagreement there, and as well as the disagreement coming out of the 3rd DCA. I would argue respectfully that I probably take the position of the 4th and the 3rd on, but the Supreme Court is yet to ask us on the merits what our view of that is, as the court is well aware, is considering that conflict right now, and is also weighing a rule, an amendment to the rules of civil procedure, or potentially a decision that would resolve that conflict. I would argue that in the court below, despite what I just said, that there was no disagreement as to the controlling standard. So while it might be expeditious or within this court's prerogative to hold this decision until that conflict is resolved, that's certainly not for me to ask, and it's for it, that would be within this court's discretion to decide.
Thank you.
One, I'd like to, with respect to the question of the affidavit, there is something approaching, and I don't mean to speak for him, a concession that the language in the anti-SLAPP statute, this is in Mr. Barrick's reply, that as a matter of textual clarity, that it looks pretty clear that under the anti-SLAPP statute, under 768.295, that a party invoking the anti-SLAPP statute is required to move with an affidavit. And we explained the difference between the requirements of the plaintiff and the defendant in our brief. It is true that Rule 1.510 specifically says that an affidavit is not required. But again, that is an entirely different animal. The 1.510, which Mr. Barrick moved under, cannot be read into the anti-SLAPP statute. It's a separate motion for summary judgment. That motion for summary judgment goes to the ultimate disposition of the case. And Mr. Barrick, which there was no discovery undertaken in this case, is entirely premature, particularly when there's issues of privilege, truth, which are by their natures fact intensive. So and then sort of branching off from that, Mr. Barrick says, well, under in today and in his brief, under Rule 1.510, with regard to the unauthenticated documents, it doesn't matter whether they're hearsay at present, because if they're reduced to an admissible form at trial, or if they could be, then they're able to be considered under summary judgment. There is no decision of this court, nor, as far as I know, of any other court in the state of Florida post amendment of 1.510 that has resolved that question. There is a great deal of disagreement among the federal courts as to whether that's correct. The 11th Circuit itself, and this includes post the amendment of Rule 56 under the federal rules, has issued conflicting opinions about whether or not that is true, whether hearsay is able to be considered a motion for summary judgment. And for instance, the First Circuit, Federal Circuit, is explicit as recently as 2021 that the general federal rule, which is that hearsay is not to be considered by courts on a motion for summary judgment under the federal standard, is still the controlling rule in the absence of any exception. So I would say that, and this might end up being way too far in the weeds for where this court is ultimately going to rest its opinion, but insofar as the question relates to the affidavit or to the unauthenticated evidence submitted with the motion for summary judgment, there's a great deal of uncertainty as to what the actual controlling standard is. And respectfully, this case is probably at this stage not the proper vehicle for that determination to be made. If there's nothing further, if there are no further questions, then I will rest and thank you for my time.
Thank you very much. So, Mr. Barrick, you have 5 minutes.
Thank you, Your Honor. I briefly disagree with the assertion that this case is controlled by Baird. Baird was a very different case. In Baird, you had the communications made not only on Facebook, but you also had them sent to the parents of students and to Hillsdale College, which the Mason Classical Academy had the contract with. And that was really a key part of the holding in that case. Baird is not you posted something on Facebook case. The you posted something on Facebook case is Davis, where the comments were posted, I think, on Facebook and Instagram, right? I mean, if we're gonna do this is the whether or not Facebook comments case, Davis is the one that's much more analogous, because Davis is the one where the comments were on, I think, as I said, I believe on Facebook and on Instagram. So that would be more related to this case rather than Mason, which is just a very different type of case and involved a whole line of case law under privileged communications alleged to be made to public entities under a line of cases called NODAR, N-O-D-A-R, NODAR, and that line of case, which really isn't relevant to what it is we're talking about today. This is a straight Davis and Gundel type analysis where the trial court did not use the burden shifting analysis that this court has instructed. With respect to the summary judgment standard at federal court. My practice is primarily federal litigation. The standard that we encounter is it reducible to an admissible form at trial? That's the standard the 11th Circuit uses, and we cited cases to that effect. That's the standard I encounter in trial courts for the summary judgment standard is, can it be reduced to an admissible form at trial? And that's, again, this court may not reach that issue, but I just want to be clear. It is my understanding that when we adopted the federal summary judgment standard, we adopted that standard as well, which is a shift, a pretty dramatic shift from what the trial courts were used to. But that's the new standard is it reducible to an admissible form at trial?
Okay.
Any of the members of the panel have any questions?
Okay.
I thank you all very much.
Well, this is a very interesting case, obviously. It's a very intriguing case, and it's sort of at the cutting edge of the law right now, given what's going on in the Supreme Court with the conflict that's been certified both by us and by the fourth. So I appreciate very much your very well-written briefs and your very interesting oral arguments today. They're very helpful to us. Thank you both. Have a good day.
Thank you.
This concludes our docket for this morning. We are adjourned to conference these cases and other cases that we have that are not set for oral argument. So have a good day, everyone.